Welcome to our California Water Colloquium series, the last of the talks for this spring 2005 semester series. I have been away on sabbatical, wandering around a little bit, so I missed the first 3 talks, but I'm here today, fortunately. And we have been very fortunate to be able to have the resources to conduct a series like this, just so that we can all educate ourselves. And this has been possible by the logistic supports from the Water Resources Center archives, and then many faculty colleagues drawn from around the campus who have been helping in identifying distinguished speakers and having them come over here. Our fall series program is almost complete. We are just trying to finalize one more speaker so that we'll be able to finalize and send the brochures and the information to you very soon. So without much other announcement to give, it is my pleasure to request Professor Joseph Sachs from our own Bolt Hall School of Law to introduce our speaker today.
Thank you, Nari. It's a great pleasure for me to be able to introduce Hal Candee, who I've known for many years. He is the chair of the Western Water Project at the Natural Resources Defense Council, a leading public interest law firm with offices in a variety of places. He's in the office of San Francisco. It would be rare that you could say with a serious look on your face that somebody embodies the public interest. But I think it's really fair to say that we talk routinely about accountability, but it's most often something talked about, and there's neither the will nor the resources to actually, in a concerted and long-standing way, try to bring accountability to public programs. But Hal and his co-workers at the NRDC have literally done this over a period of years, almost 20 years, I think, at this point, which I know represents his tenure at NRDC, in bringing accountability to the Bureau of Reclamation and to the water programs that it has in the state of California. He has been instrumental in bringing to light the need to re-examine these water contracts that the Bureau has when they come up for renewal, something that would have passed without any kind of public attention had it not been for him and his work, and has done a marvelous and important job in bringing attention and legal restrictions to bear on that. I think he's going to talk today about or primarily at least, about the San Joaquin River and the important work that's been done there, again, under his leadership to begin the process of restoration on the San Joaquin River. He has a case now pending before the U.S. Supreme Court, which he will win. Not everybody knows that, but you now know it because I've announced it, and it will happen. And it will happen in significant part because of his and his colleagues' wonderful work. So without any further hesitation, let me introduce Hal Candee and welcome him to this seminar. you've got to deal with this yourself.
This is the really hard part of the... Can you all hear me all right with this microphone? Okay, great. Well, thank you, Joe, very much. That was a very gracious, kind introduction, with the one exception of predicting the outcome of a pending court case in the U.S. Supreme Court. That is not, that makes me nervous when you, when you do that. The case Joe's referring to is not the case I came to talk to you about today. It's a different case involving other water users in the San Joaquin Valley. It's called the ORF case, and if there's time at the end, I'll be happy to talk a little bit about it. It involves a lot of the same issues of federal water contracts and environmental protections for San Francisco Bay Delta, but it's actually a little different than the case I am here to talk about today. Let me just first say what an honor it is for me to be here today to speak to you, and also to be introduced by Joe Sachs. He's really one of my great heroes. Joe is an inspiration to all of us who work on Western water law in this country, and not only brilliant and extremely influential, but is kind enough to allow me to continue to pester him from time to time with lots and lots of questions and requests for guidance. Also, I want to pay tribute to the Water Resources Center archives. It's just an amazing resource. We at NRDC use it all the time, and people throughout the environmental community use it all the time, and you all are very fortunate to have it right here. Everything there is to know about water and all of the resources you might need are here, so it's terrific. One last quick acknowledgement I want to make, and that is a friend of mine is here, a local businessman named George A. Miller, and I wanted to put him on the spot and embarrass him because George, he calls himself Local George. That's to distinguish him from the congressman named George Miller, but they share a passion for water. And George is a big supporter of the University of California, and he's well known to everybody in the environmental community. But one of the great joys in life is to go to a Bureau of Reclamation workshop on water contracts and water policy, and have this retired financial wizard raise his hand and say, "Why are you selling the water to these agribusiness farms for $30 an acre foot and then buying it back from them for $130 an acre foot? Isn't there something wrong? And wouldn't that create a shortage of just about anything if you played that game?" And they never have an answer. They always they look baffled by the questions. So anyway, finally, just one quick disclaimer. NRDC represents a broad coalition of organizations in our work on the San Joaquin River, 14 conservation and fishing groups, but I'm here today speaking just on behalf of NRDC. Nevertheless, I did want to mention that we also have in the audience some people from some of the coalition members, including the Bay Institute of San Francisco, a very important member of the coalition that has provided terrific technical and policy support. One thing that all of us in that coalition share is a belief that it's the right of all of us to have healthy and clean rivers, and that if we work now, today, to restore the San Joaquin River for the future generations, that there will be benefits throughout the state, benefits throughout the region, the San Joaquin Valley, Southern California, Northern California, that will be important economically, important spiritually, important for our quality of life. And so that's what motivates all of us in our coalition to work for over 16 years now and counting to try to restore the San Joaquin River. So the topic is, we titled the talk, "The Ongoing Battle to Restore the San Joaquin River." And that topic was selected very carefully because it is ongoing. In fact, this year, despite 16 years of litigation, it's probably having the most important battle of all. We're about to go to trial in about 9 or 10 months. And second, it is a battle. There was a time for 4 years when it was a consensus effort, and I'll talk a little bit about that. But right now it's pretty contentious, and I'll get into that a little bit. Finally, I should mention that the wonderful folks from the archive staff asked me if I wanted to bring any photographs or PowerPoint or whatever. And my first thought was that I should really bring pictures of my family, because when you work on a case for 16 years, they really get a sense of ownership of your case, and I can't say they love the case. In fact, in some ways they don't love it at all, but it's very much a part of our life. But I didn't bring any overhead. I did bring a brochure. There's a few copies here, and you're welcome to come up and look afterwards. It has some pictures about the river before and after the dam was built at Friant Dam, which I'll be talking about. There's also a map up here that shows the whole geography. Joe assures me that all of you know a lot about the California water situation, so I won't spend a lot of time, but let me just start by giving just the briefest of background, briefest of overview. The San Joaquin River is one of the major rivers of our state, over 350 miles long, the second longest river in the state. It starts up high in the Sierras, south of Yosemite, and flows past Fresno. When it gets to the small town of Mendota in the middle of the valley, it turns north. And it's important to keep Mendota in mind because some interesting things happen in Mendota. Anyway, it flows up to the Bay Delta estuary, and as you all know, the San Francisco Bay Delta estuary is a major resource, largest estuary on the west coast of North America. The San Joaquin River supported a magnificent salmon run. The San Joaquin River was one of the largest sources of fresh water for the San Francisco Bay Delta estuary. It is a crucial resource. It was crucial to the natural wetlands in the San Joaquin Valley around the grasslands area. But in the 1940s, the US government had a very interesting idea, and that was, let's build a dam near Fresno called Friant Dam, and let's take all the water out of the river. And that's what they did. They dried up the San Joaquin River. And what they did is they divert the water south through the Friant Kern Canal, way out of the basin in the area of origin, past Bakersfield to Arvin Edison Water Storage District. They ship it north to, through Madera County on the Madera Canal, and they provide over 2 million acre-feet of water in these federal water contracts that Joe mentioned, and they release none, zero, for the downstream environment. There's a little bit of water they release for the first 35 miles, but that's for other farmers. That's for the riparian landowners who were diverting historically. But they don't release any water for water quality, for wetlands, or for fish. And the results have been devastating, as you might imagine. The other part of what the Bureau of Reclamation did, the Bureau, as you all know, is the large federal agency inside the Interior Department that runs water projects in the 17 western states. They run the largest water project in the state of California. That's called the Central Valley Project. That's also the largest of all the reclamation projects. The Central Valley Project includes Friant Dam. So we're talking here today about trying to reform one of the oldest and most important features in the massive Central Valley Project. But the other piece of this engineering operation was we're going to take all of the San Joaquin River water out of the river and send it down to Bakersfield or up to Madera County. And then what we're going to do to meet the needs of the farmers downstream on the west side, the so-called exchange contractors, the land of Henry Miller and the west side cotton growers, we're going to bring Sacramento River water out of the Delta, bring it back, and dump it back into the San Joaquin River at Mendota. Now, perhaps you all know this already. Some interesting things about that. Those farmers are now complaining that the water quality they're getting from the Delta is so inferior to the water quality they used to get from the San Joaquin River that it is causing them to violate water quality standards, that the salinity of the water they get for their farming on the west side is the problem. And then, of course, when they run it through their irrigation cycle and we have the return flows back down the river, that aggravates the water quality problem. The U.S. District Court, which is hearing this case in Sacramento, issued a major ruling last August, which I'll be talking about, and what was at issue was whether or not this drying up of the river was lawful under state law and under federal law. And as many of you know, we won that liability ruling, and the court found that it violated actually both state law and federal law. But in the course of reaching that decision, the judge, Judge Lawrence Carlton, issued some findings at the beginning. And I just want to read a few of them to you because I think it helps set the stage for our talk. By the late 1940s, the Bureau of Reclamation's operation of Friant Dam had caused long stretches of the river to dry up. While the salmon continued to return and spawn until 1949, after that, the San Joaquin Chinook was extirpated in its southernmost range. Some 60 miles of the river, upstream of its confluence with the Merced River, now lie continuously dry except during rare flood events. He goes on, not just talking about fish impacts and the impacts to salmon, but also more generally about water quality downstream. Failure to release water from Friant Dam has also adversely affected water quality along the whole course of the river. Today, the first several miles of the San Joaquin River deep water channel near Stockton experience dissolved oxygen levels that are so low during summer and fall months that they do not meet the state water quality objective. Reduced flows in the San Joaquin below Friant have diminished the area available for fish, reduced the ability of the river to assimilate agricultural runoff and other pollutants, and substantially degraded riparian vegetation. Many of the fish that are still in the area are contaminated with pesticides and other agricultural contaminants. What the court found in August was that drying up this river cannot be deemed reasonable under state and federal law. And that was a huge and important finding, one that we are now going to go to trial on the very important question of, well, what do you do about it? How do you remedy this? Anyway, let me go back and put this in a little bit of context. I should mention that a very interesting thing happened in the 15th year of this case, in the summer right before this August ruling. This case had been brought by environmental fishing groups, but we were joined at the last minute right before the liability ruling by an amicus brief by two agricultural districts. The extremely conservative farmers from the Central Delta and South Delta Water Agency. They happen to be the strong supporters of Congressman Richard Pombo. They are all active Farm Bureau members and don't normally agree with NRDC on environmental policy, but they wrote a brief on our side in the case, and they said, what's happened to the San Joaquin River is a national disgrace. And why did they say that? Because it has hurt the farmers downstream to have no clean water coming from the upper San Joaquin. It has hurt their communities, it has hurt both their water quality and their water supplies. And so that was the context in August. Anyway, let me back up 16 years here and talk about how did NRDC get involved in this issue? Why did we first get involved? In 1988, the Reagan administration was confronted with something that hadn't happened before. The first of the long-term water contracts for the entire Central Valley project were about to expire. And everybody wanted to know, okay, what are you going to do? So we wrote some letters and said, you know, the decision to renew 40 years worth of contracts, these are all 40-year contracts, the decision to renew them and to dry up the river again for another 40 years, that's a big decision. In fact, in the federal environmental statutes, we call it a major federal action. And you know what? Drying up the second largest tributary to the Bay Delta estuary, that has a significant environmental impact. And so for those of you in the room who know about NEPA, the National Environmental Policy Act, it seemed kind of straightforward, you know? Major federal action, you're making a decision, huge impact, do an environmental impact statement. Doesn't dictate the outcome, but you at least look at the impacts and you consider alternatives. So we sent that letter off, got no response. So we asked for a meeting, and we met with the Bureau of Reclamation officials, and they, without telling us, brought in the managers from some of these 28 districts that get this water up and down the east side of the San Joaquin Valley. And we said, look, we're not trying to make your lives miserable. We're not asking for a lot. Give us a little bit of water. At that point, we weren't talking about salmon. We didn't even have a vision, just a small group of us. Just agree to do an EIS or EIR, look at the alternatives, agree to release some water. I mean, you're getting 2 million acre-feet of water. You can release some. And we'll get out of your hair because we're really looking at the guys on the west side, Westlands Water District. Now, there's somebody we're really, but their contract doesn't expire for a while. And, you know, there's all these nods, some people thinking, this doesn't sound unreasonable. We could do. And all of a sudden, the lawyers chimed in. I didn't realize they had brought the lawyers for the water districts. And they said, and they weren't just talking to us, they were talking to the federal officials. These are Reagan people. If you even think about changing the way we operate Friant Dam, if you even think about changing the terms in these contracts, you are offending our historic water rights. You have no right to any water, you have no right to change terms, and if you do, we will see you both in court, you know, looking at the Bureau, looking at NRDC. And I said, if you want to do that, that's okay. But I don't really think that's a great idea. And they were hardline. Well, needless to say, they got their wish. They did see us in court, and they have been seeing us there ever since. But it was really a tragedy because, as I say, the managers, not the lawyers, the managers of the room kind of got it that this might be a smart business decision to work something out. Anyway, what happened is 1988, of course, was the presidential election. Reagan's term was over. So 2 days after the election, the top lawyer for the Department of the Interior, a man named Ralph Tarr, decided the issue. He waited till 2 days after the election. And Mr. Tarr, as some of you may know, was a prominent water lawyer in Fresno, interesting place, since Fresno receives water from the Friant Dam. Before he went to the Interior Department, he issued a decision saying, there will be no NEPA review. There will be no environmental impact statement. There will be no consideration of environmental impacts or alternatives because these people have a permanent entitlement. Permanent entitlement. That's appealing, isn't it? California has changed so much in 40 years. It's going to change so much in the next 40 years. But these deals that were cut in the 1940s, those are locked in. And we looked at that, and we talked to others, and we realized this policy isn't just about Friant Dam. This isn't just about this unit. This is about the whole Central Valley project. In fact, this is about all of the federal water projects in California and other western states. This is an idea that once we cut the deal in the 1940s, we're done. And we, in fact, don't need to obey subsequent acts of Congress, the National Environmental Policy Act, the Endangered Species Act. Clearly, we could not accept that. We could not let that stand. But interestingly, it wasn't just us. We had an interesting ally, another agency of the Bush. This was now, by the time things got going, it was the end of the Reagan administration, beginning of the Bush administration, the first Bush administration. The US EPA agreed with us. They said, you have to do an EIS. Of course you've got to do an EIS. There's all these water quality impacts. They're trying so hard to restore the water quality in the Delta. And of course, you're making a decision. You have the right to sign or not sign the contract. Well, what happens when the U.S. Department of the Interior says NEPA does not apply, and the U.S. EPA says that NEPA does apply? What do you do? Well, it turns out there's a little section in the Clean Air Act that says when that happens, you go to the White House. And there's a special office in the White House right next to OMB called the Council on Environmental Quality, CEQ. And those of us who work in this area know that CEQ is charged under NEPA with interpreting NEPA and applying the law. And they have all the regulations for implementing NEPA. So they actually had hearings. We all went to Washington. We all went to Fresno. Big hearings, a lot of people there, congressmen testifying. And they heard testimony. And what did CEQ, this agency appointed by President Bush, what did they decide? EPA is right. The NEPA does apply because there's discretion. Yes, you may be right that they have a right to a renewal contract, one way or the other, but the terms of the contract, you're going to change the terms anyway. Hopefully you're going to raise the price. They'd been charging $3.50 an acre foot for 40 years, fixed price, nice deal. Santa Barbara at that point had announced they were prepared to pay $1,700 per acre foot of water if necessary during the drought. Somewhere between $3 and $1,700. Hey, there's got to be some movement. Turned out the Bureau was thinking of going up to $20 an acre foot. But anyway, CEQ said, you really have to do an EIS, and you have to consider your alternatives. And one of the things you have discretion over is the quantity of water in these contracts. So we thought, oh, that's great. Not only did EPA agree with us, now the issue's been decided, CEQ agrees with us, and now we have a new administration, so they're not bound to do what the Reagan administration said. Wrong. The Secretary Manuel Lujan agreed he had to do something different than what the prior administration, but he couldn't bear to undo any of these contracts. They had actually been on the verge of signing the first of these contracts. So what he did is say, well, we're going to have it both ways. We're going to go ahead and sign the contracts and lock in the terms, roll them over, same terms as before, but we'll do an environmental study of what to do about that and how to make things better in the future. And we're like, wait a minute, you've taken all the water and you've promised all the water, and now you're going to leave the river dry. The contract issue played out for a number of years. We filed our lawsuit under both the National Environmental Policy Act and the Endangered Species Act. The Bush administration went ahead and did this totally crazy after-the-fact study, which nobody took seriously, and in fact, I think they never finished it. It kind of became a silly joke. And then the US Congress got involved. And so, we've had a lot of setbacks over the years, but there were three very interesting things that happened. First, we got federal agencies to agree with us and CEQ to issue this very important precedent-setting decision that, yes, NEPA applies. Second, Congress looked at it, held hearings, and they changed the law. They said, whatever you may have thought the law was before, in 1992, the Congress said in CVPIA, the Central Valley Project Improvement Act, affectionately known around here as the Miller-Bradley Law, because Congressman George Miller from the Bay Area and Senator Bill Bradley from New Jersey were the co-authors. It said, before you renew any more contracts in the Central Valley Project, you must comply with NEPA, you must comply with the Endangered Species Act, you must do an environmental impact statement. And then finally, there were 14 contracts that had snuck in before the 92 law. We continued to litigate those, and in 1997, the judge invalidated every one of them under the Endangered Species Act. The Clinton administration refused to appeal that ruling, but the farmers did. We went to the US Court of Appeals, and we won a unanimous decision, NRDC versus Houston. The last name in this case, I should mention, changes. It was filed as Houston, then Patterson, and now it's NRDC versus Rogers. It all depends on who the federal official is at the moment, but in NRDC versus Houston, the Ninth Circuit Court of Appeals said these contracts violated federal environmental laws, they must be invalidated, and that's what happened. However, by then, by the 1990s, it was clear to us that this exclusive focus on the contracts wasn't getting any water in the river. And we weren't even sure whether it would get water in the river because, of course, the requirements under NEPA and the Endangered Species Act are procedural requirements. They don't dictate the outcome. So back in about 1989, 1990, 1991, we started looking around for other claims to bring, substantive claims that would actually lead to water being released from the dam for the downstream environment. And we talked to a lot of the different people we were representing, the striped bass fishermen from the Stockton area, the commercial fishermen, PCFFA, the national and local environmental groups, and we all looked to the Mono Lake controversy for inspiration. And those of you in the room who've worked on Mono Lake know that how important a particular section of the Fish and Game Code had been. It's not just the public trust doctrine in general, which was so important in Mono Lake, but there's a specific section of the Fish and Game Code called Section 5937. And what it says is that the owner of every dam in California must release water for fish, must release enough water to keep the fish in good condition. Now, we, of course, once again asked the Bureau, would you care to obey this law? And they said, oh no, our policy on that is clear. We're exempt. We're exempt. That's a state law. We're the federal government, got it, we don't obey that state law. And we said, well, there's this guy named Chief Justice Rehnquist, and in this very important case involving New Melones Dam, a little bit farther north, the Supreme Court said, states' rights. When the federal government comes into a western state like California and you seek a permit to appropriate water, you have to obey state water law. Guess what? This is part of state water law. They said, we are not going to comply with 5937. At this point, all the irrigators were intervening in the case, the irrigation districts, and they said, besides, there are no more fish. So we don't, we sort of killed our way out of it. And second, if we had to release water for fish, then we should just release enough for whatever planted fish there are below the dam. And we said, well, actually, if you look at the Mono Lake precedent, if you look at the California trout, the Cal Trout decision in the Mono Lake, the state courts have said you can't dry up a river and get out from under this law. You have to restore the historic fishery. And we said what that means on the San Joaquin River is the historic salmon. Remember, the San Joaquin had a magnificent spring run Chinook salmon run, hundreds of thousands of fish. It also had a fall run salmon run. It had other native fish. And we said, that's your duty. Under the Federal Administrative Procedure Act, the federal government is required to comply with state law because in 1902, when the first reclamation projects were being built, the Congress said you must comply with state law when you're operating these projects. And what the US Supreme Court said in California versus the United States is that you must defer to these state laws unless there's a clear conflict with a congressional directive. In other words, if the Congress says don't obey state law or there's an absolute conflict, then you're exempt. Otherwise, you must comply. Well, that became the crucial other claim in our case. And I mentioned before that after 10 years of litigation in 1997, we were successful on the contract claims in invalidating the contracts under the Endangered Species Act. The other thing that we were successful in doing was establishing for the first time that federal law, the Central Valley Project, the authorizing statutes for the Central Valley Project, do not, what they call facially preempt state law, including Section 5937. In other words, the argument from the federal government was, we don't even need to think about what it would mean to comply with 5937. We don't even need to think about what it would mean to release enough water for salmon or for other fish, because we're exempt, from the whole thing as a facial matter. That decision was rejected by the district court, and then on appeal, the U.S. Court of Appeals, again unanimously, said, that's just plain wrong. That's not the law. Well, I got to tell you, one of the interesting aspects of this crazy litigation, this is all happening in the mid to late 1990s. We're walking into court, and it's us on this side and the irrigation districts on the other, and you understand that. But we also had on our side the state officials, and on the other side they had the federal officials, which meant we had Dan Lundgren and Pete Wilson in our corner. We had the State Water Board appointed by Pete Wilson and the Attorney General, Dan Lundgren, now a congressman, and they had the federal government, the mean, evil Bureau of Reclamation, Al Gore, Bruce Babbitt, my former colleague John Leshy. I mean, they were all over there. It was very strange, which may say something about why the Clinton administration decided not to join in the appeal. It was really the irrigation districts that brought the appeal. Okay, so what happened? What happened after we had this big victory? Unfortunately, the case was not over. The judge had not said what it means to comply with 5937. The judge had not said how much water will it take to restore the salmon. And the Ninth Circuit sent the case back and said, the court must continue these proceedings and must determine what it means to comply with this law, which has never been done for 50 years. This river's been dry most of the time for 50 years. And then he said there's a remaining question, which is once you've determined how much water will be released, then you go back through the preemption analysis a second time. Is that somehow in conflict with other governing federal laws or somehow in conflict with the state constitution? Would it be unreasonable to restore the native fish to California's second longest river because it's just too much water or the impacts would be too bad, too severe? And that's a very serious set of questions, and that is exactly what we are now working on in preparation for trial for next year is what will it take to restore the historic fishery, how much water, what other measures must be taken, and what will the impacts be, and is that all lawful? So there is no final decision yet. Nevertheless, the decision in 1998, which was so sweeping and as I mentioned, unanimous, and which, by the way, the irrigation districts then tried to overturn at the U.S. Supreme Court. And the Supreme Court, first they tried to overturn it at the U.S. Court of Appeals en banc. They didn't get one vote in the entire en banc panel to revisit the decision. Then they tried to overturn it at the U.S. Supreme Court. That was denied. The day that the U.S., actually it was the day after the Ninth Circuit panel ruled for us, the phone rang. And we got a call from the leader of all 28 Friant contractors, what they call the Friant Water Users Authority, saying, we'd like to talk settlement. We'd like to talk to you about working together to implement some kind of restoration on the river. And that was a very important moment. I mean, this was, again, where we started. When we first talked to them in the 1980s, we said, look, you're crazy. You can't do this forever. Let's try to do this in a consensus manner. Let's try to come up with a flow. And so finally, after 10 years of litigation, they were willing to talk to us. Now, I should put this in some context about why we were so convinced that it was possible to do this, that farmers and environmentalists could work together to restore this river. Remember that the federal government, when it delivers this water to these irrigation districts, believes that the regime that was put in place in 1902 is still the right one, and that is interest-free. All the costs are subsidized, whether it's the power cost for pumping, the storage cost. A lot of the costs are written off for recreation purposes. So the prices are kept at the lowest possible level. And second, the farmers there, who are very ingenious at moving water around, have never tried to actually manage their system for a component to go down the river. You know, they never actually tried to add that into the equation. But we were convinced that there's so much plumbing in the San Joaquin Valley, there's so many ways to exchange water, to reoperate facilities, that if we just sat down and tried to do it together, we could actually restore flows to this river and have minimal impacts to the farmers. I should mention also there's also some urban use, not much. In the Central Valley Project, about 90% of the water goes to agriculture as compared to, let's say, 80% in the whole statewide. But there is one very large city, the city of Fresno, which has recently taken up the leadership of condemning the idea of restoring the San Joaquin River. It's interesting, the major urban water agencies got together a few years ago and created something called the Urban Conservation Council. And they issued a letter in 2003 identifying the city of Fresno as having the highest water use per capita of any city in the state of California. I mean, this is a place that had bountiful, plentiful water, and they weren't conserving. So once again, we thought, well, even your urban users could conserve. So what we did with the settlement is we did something which some people thought was crazy. We put our case on hold. We said, okay, we're winning at every level. We've been sent back to go to trial to figure out the final thing. But these farmers tell us they're serious. And we're going to put the case on hold. And in exchange, they agreed to work with us to restore not just flows into the river, but flows from the dam to the delta, and to restore the historic salmon fishery. And what did we agree to do in exchange? To try to do that in a way that minimized any impacts to their water supply. And the result was 4 years of very interesting studies and experimental projects. The studies looked at how do you do it, how do you restore the fish, and also where do you come up with the water, how do you find the water. And the experimental projects were even more interesting. In our first or second year, we convinced some of those Friant districts to release some of their water from behind Friant Dam right smack in the middle of the summer when everybody is trying to get as much water as they can for their irrigation, into a part of the river that's never seen water in the summertime. It's always dry in the summertime. And that water went from Friant Dam all the way down to Mendota Pool, and then and creating benefits all the way down. I remember going out there in July and August and seeing kids playing in this part of the river that's usually dry and sandy, and it was an inspiring thing. But mostly we were trying to bring back the riparian vegetation, trying to study, understand the natural processes that were finally at work again. But what happened when that water got to Mendota Pool is that the farmers on the west side, who, as I mentioned earlier, normally get a water supply now from the delta, they took this higher quality water from the San Joaquin River and they used it for their irrigation needs. And then in exchange, the water they would have pumped, the Bureau of Reclamation would have pumped to these people, these exchange contractors, was switched over and pumped farther south back to Bakersfield, back to the Arvin Edison Water Storage District, and they got makeup water. Now there was a higher cost. It costs more in pumping and other maintenance costs to bring water from the delta all the way south down the California Aqueduct and move it east towards Bakersfield than it does to just bring it down the Friant-Kern Canal from the Friant Dam along the east side of the valley. Who paid that cost? The CalFed Bay Delta program paid for it the first time. Why? Because this was a new concept of bringing federal and state agencies together to restore the Central Valley ecosystem, restore the Bay Delta estuary. This was something that CalFed, the federal and state agencies who care about the bay and the delta, were very interested in. Let's try to get this river restored. So they paid those costs. Other experiments after that were paid by some of the water bonds, the propositions that we've all been voting for, Proposition 204, Proposition 13, Proposition 50. These are important water bonds. And so we felt there was money available to do this kind of creative stuff. So what happened to settlement? Why are we talking about an ongoing battle? What happened is that after 4 years, or after 3.5 years, it was clear to everybody that studies were taking longer than we thought. The experimental projects weren't turning into long-term commitments. It was just, these were short experiments. And we were basically staying out of court without any kind of final solution, final agreement and settlement to restore the river. So we decided we needed to focus on coming up with a deal, a final agreement that would settle the case. Both the Friant lawyers and irrigation district managers and the NRDC coalition, the fishing and environmental groups, felt that we were going to need help. So we jointly asked the U.S. Court of Appeals, which had decided the big issue in this case in '98, to assign the chief mediator for the U.S. Court of Appeals to try to help mediate this case. And for 6 months, this wonderful gentleman had confidential meetings with 4 representatives from the Friant side and 4 representatives from the NRDC environmental side. The U.S. government chose not to participate, and which was fine with both of us, basically the farmers and the environmentalists. And after 6 months of receiving proposals from both sides and hearing all of the different issues, the mediator came up with a compromise. It did not give us anything like what we thought we would win in court and what we were, felt was our entitlement. And it didn't give them anything like, what they thought would be a pain-free, easy way out of this whole thing. It was a compromise. But it would have, over time, led to restoration and make-up supplies of water to the Friant farmers. It would have had a package that could work. And so for a month, and the other thing the mediator said is, this is it. I'm sick of you all. It's been 6 months. I've worked on this with you, and I believe this is a fair compromise based on what I've heard from both sides. So basically, take it or leave it. We're not going to, because he could just see, we're going to nitpick here. At this point, there are 15 organizations on our side, 18 on their side, plus a trade association. The 15 on our side, after a lot of difficult debate and all that, decided we could live with the compromise, and we would shut down our lawsuit, accept this settlement, and go through the process that it involved. The Friant farmers rejected it, and they rejected it in a way that wouldn't tell us how many, whether it was all and nothing, or whether it was 90% were for it and 10% against it, and that's because they have a rule. They have a rule in their Friant, they all come together in the Friant Water Use Authority, and the rule is, if any single district vetoes it, they all veto it, and that's called the Russian veto. So we won't ever know for sure. We are told by Fresno environmentalists that actually the majority were for it, but we don't know. It's interesting that a year after this, they broke up the old authority and created a new one, identical new one, that dropped out 2 members of the old authority, which just happened to be the most radical anti-environmental members, so maybe that's what it is. But in any case, there we were, 4 years of settlement talks, 4 years of effort, and no deal, no settlement. I should mention that the world was changing. In the 90s, we had big surpluses at the federal level, big surpluses at the state level. We had big propositions. There was a lot of money around, and people thought deals like this could be funded easily. By 2003, that wasn't the case. We were heading back into deficits. We used to have an administration in Washington that was in favor of these kinds of environmental agreements, that was trying to promote this. By 2003, we had people in both the executive branch and in Congress calling for the repeal of the Endangered Species Act, who were talking about property rights. I think a lot of people on the Friant side felt, hey, maybe we don't need to give up anything. Maybe we'll just give this a try without a settlement. So the case went back to court. And that's what led to the decision last August in 2004 about how do we finish this decision about how state law applies. Now, I should mention, during the course of settlement, the contractors came back to us and said, well, we still need our contracts. You invalidated our contracts. What about our contracts? And so we actually reached a strange agreement as part of the settlement, which said they can get new contracts provided they change some of the terms of the contracts and say this contract is subject to this lawsuit and this settlement. And if NRDC gets a settlement or wins the lawsuit, the contracts must be changed to implement whatever comes out of that case. And it also gave us an agreement that said we can sue to overturn the contracts completely once the settlement is over. And so that was one of the things we did. We immediately filed a new claim against the contracts, and those claims are being heard right now. The judge has received argument on the Endangered Species Act claims, and he'll hear more arguments this summer, but no decision yet. But the other claim, the one that I mentioned earlier that's still at issue, is how do you reconcile this state law, which clearly says that the owner of every dam must release enough water to keep the fish in good condition, with this Bureau of Reclamation project that dries up the river and diverts all of the water. And the the parties briefed that issue for a year. Again, we had amicus briefs from the state of California, very, very important to have the state of California coming in, helping the federal court understand what the state law provides, rejecting some of these arguments. The federal government and the water users had made the argument that we got a permit in the 1950s, and the permit didn't say you had to release any water for fish, so we're done. That's it. The court, you have no jurisdiction. You can't second guess what the water board did in the 1950s. Well, we pointed out that that's not the law, and if you read the permits themselves, it says, as of this moment, we allow you to divert up to this amount. But it really helped to have the state water board itself come in as an amicus and say, that's not what the permit says. The permit says you may divert up to this point, but it doesn't say you'll never be required to release some of that to the environment. They also said that they were making a finding as of that moment in the 1950s. And finally, they said the Fish and Game Code, this 5937 section I keep mentioning, is an independent duty. It's an independent obligation of every dam owner, and it applies to the federal government, and you're not exempt from that law. Well, in August of 2004, the district court in Sacramento did issue the ruling, and it's a very important ruling because he has found that 5937 does apply to the federal government, that it does apply to Friant Dam, that it does protect the historic fisheries. You can't dry up a river and get out of it, and that the drying up is unreasonable. But what the court did not yet decide is how to remedy that, and that's where we are today. I think the issues that have come up along the way are pretty interesting, and actually I think in some ways the Friant case is a pretty good example of what we see as the mismanagement of the Central Valley Project. The whole notion that you can lock in these contracts and never tinker with them, never re-examine those decisions, never do a subsequent environmental review is very much at issue today. The rest of the Central Valley Project has 230 water contracts, long-term water contracts, and they're all up for renewal. It is true that in 1992, the Miller-Bradley Law, the Central Valley Project Improvement Act, adopted new requirements. The terms, for example, must be 25 years, not 40 years. They must have an EIS before the contracts are signed. They must have what they call tiered pricing, so the price goes up the more you use to try to encourage conservation. You must start measuring the water in your district. Somehow, the Bureau of Reclamation and the Department of Interior have found a way to get around or weekly implement every one of those reforms. For example, half of the contracts they are now proposing are not 25 years long, they're 40 years long, because they claim that there's loopholes and exceptions. On the tiered pricing, they only want to apply the higher prices in the flood years, which happen 1 out of 10 or 2 out of 10. On and on it goes. So we have been filing comments, we and others in the environmental community, urging the Bureau not to make the same mistakes in these other parts of the Central Valley Project. So whether the water's coming from Shasta Dam or Folsom Dam, whether the water is exported out of the Delta through the massive pumps, let's try to do more with conservation. Let's try to do more with protecting the water quality and protecting the native fish. And as you may have seen in the recent press, the fisheries in the Delta are now in sharp decline, notwithstanding the noble efforts of the Cal-Fed Bay Delta program, notwithstanding the massive amounts of money that have been spent to try to restore some of these ecosystems. The fisheries in the Delta, the water quality continues to have huge problems. We are told that that's sort of basically tough because we have to have this water for agriculture. We have to have the subsidies. We have to have these long-term contracts. And I'll be the first to say, agriculture will always get a huge share of water in California. That agriculture, if the choice is between the Fresno Irrigation District getting the water for crops versus the housing developments around Fresno and the urban sprawl, that it's not like the choice should be let's give up on the farms. Obviously, the farming is a crucial part, but the kind of rhetoric that we are being subjected to. There was a full-page ad in the Sacramento Bee this morning, for example. Federal water contracts are the key to keeping small family farms in California. I mean, you know, that's the level of it. Restoring the San Joaquin River will destroy the economy of the San Joaquin Valley. In the 1980s, I worked on the Kesterson Wildlife Refuge, where we were told that, that killing off all the migratory birds in this wildlife refuge because of agricultural drainage had to go on, because if you stopped it, you would basically wreak havoc in the San Joaquin Valley. That wasn't true. In the 1990s, we were told that if the Friant contracts were invalidated, that would wreak havoc and everybody would lose their jobs. That wasn't true. And now we're being told that this year that restoring the San Joaquin River or tampering with these new contracts will again wreak havoc. A top official in the Schwarzenegger administration made an interesting observation a couple of weeks ago. He said, I'm hearing so much from the agricultural industry about California water policy. They keep saying how crucial agriculture is, and that's why they should get 80% of the water. So he said, I looked it up, and it's true. They're probably the largest state agricultural industry in the country. It's a gigantic industry, but it's tiny in the California economy, tiny. In fact, the entire $28 billion California agricultural industry is smaller than a single Silicon Valley company, Intel, considerably smaller. And yet, 80% of the water is going to this one part of the economy. And you know, for the business people in the Schwarzenegger administration, that was a revelation. I mean, you know, it's like, wait a minute. And then they looked at another fact. There's like, Southern California, there's been this massive urban growth, the population growth in Southern California, just steadily going up. But you know what we've been looking in over the last period of years? The water use is staying constant. It's not going up. Why? Because they're conserving. People are using just basic common sense notions of low flow showers, or trying to use better landscaping, or trying to have the water districts educate the people about water conservation. So conservation is possible, and there is a possibility for some balance, and we still believe that what we studied during our settlement process can work on the San Joaquin River. What we found, the folks at the Bay Institute and NRDC and the Friant water users and the Bureau of Reclamation, in 2 years of study, we looked at 72 different water management techniques and strategies, from everything from raising Friant Dam, making it a larger reservoir, to basic groundwater banking and conjunctive use, increased urban conservation, increased agricultural conservation, voluntary markets and exchanges, reoperation of the facilities, the whole gamut. And we screened those all out and screened them to come up with 5 bundles, different bundles of strategies. And if you put them together, could you meet the likely restoration demand? And we found that all of them, we could make all of them meet the restoration demand. Even if you ramped way down on urban conservation and just assumed a very small amount. Even if you tried to minimize any kind of water markets that could have any possible third-party impact so that you protected your communities. We found that there's lots of different ways to do this. And interestingly, the most expensive was the building of new dams. You know, we looked at a lot of different new surface storage options. They always ended up taking the longest to implement, costing the most, and having the most controversial impacts. But there's so many other things that can be done. So we believe, whether it's in the trial next year in the court, whether it's in the state legislature or the debates in Congress, that if people give this a fair shot, if you look at the options, the alternatives that are out there for managing water in intelligent, modern ways that use all of the strategies, all of the techniques that are out there, you can restore a major resource like the San Joaquin River and bring benefits all the way downstream and still have an extremely strong, robust agricultural economy that's been depending on that water for years, and continue to let Fresno meet its needs as well. We think that's the promise of the future. We're very pleased that Senator Mike Machado from Stockton, state senator who used to chair the Agriculture and Water Committee and is now the chair of one of the relevant subcommittees, has introduced a bill this year to do exactly that, to put state money into 2 things: helping to restore the fishery, helping to restore water quality by bringing flows from Friant Dam all the way down to the Delta, and second, trying to invest in better groundwater management and groundwater banking programs, invest in water exchanges and water transfers and any other strategy that will help make up some of the water to the existing users so that restoration of the river goes in a positive, balanced way that has as minimal impacts as possible. That bill, SB 350, is still pending in the state Senate. There's been opposition to it, oddly enough, from some of the agricultural folks who would actually benefit from that second half of the of the proposal, but we're hopeful that that will actually pass this year and help get the state of California on the side of trying to restore this river or provide the funding. It doesn't interfere with the court case. It basically is there in case the court makes a final decision and restoration proceeds. I have talked to you all a lot nonstop, and I apologize for that. I want to leave plenty of time to answer any questions. Let me just end by saying this has been a long battle, a long struggle for over 16 years, but it's really been an inspiration to work with some of the environmental groups in Fresno, to work with some of the farmers in the Stockton area, some of the different folks up and down the river. And so many of them, it's interesting, so many of them have come to us and said, you're on the right track, and you're going to win. Everyone knows the river is going to be restored, but I can't say that publicly. I can't come out and support you publicly. I'm sorry. People will be very upset if I do that. Water districts coming up to us saying, we will do much better. We will do much better if you win and the river is restored. But sorry, we can't file any briefs on your side. We can't take that position publicly. Finally, when we won the big decision last August, the director of the state's Department of Water Resources testified to the state legislature, this is going to help the whole state. This is going to help our fishery problems in the Delta. This is going to help water quality problems down the river. This is going to take some of the pressure off some of the other reservoirs that are currently bearing the brunt of the water quality standards. And this is going to help the state water project, which is trying to meet the needs in San Diego and Los Angeles through Delta exports. And the state, for the first time, kind of got more public about the benefits. The Attorney General, representing the Water Board, said this was a huge victory for all of Californians who care about the public trust doctrine and trying to restore public trust resources. So we're starting to see more visible, more public statements in support of this restoration effort. But at the same time, the rhetoric in opposition has gotten more shrill. And there's a group in Tulare County and Kern County and Fresno County who are realizing that you can do very well in your political career in that neck of the woods if you denounce river restoration as a black and white, all or nothing attack. Say that it's those people in Berkeley who are trying to change the way things are. It's those Bay Area environmentalists. When the farmer from the South Delta Water Agency went down to Fresno recently and testified, and he talked about how the farmers in his district had suffered for 50 years as a result of this Bureau mismanagement upstream, there was silence in the room. There were all these Fresno and Visalia and Bakersfield legislators there, and they didn't have a response, because what they had been sort of told was that this is all about Bay Area environmentalists and all they care about is fish. But this is about people all the way up and down this river. This is about people in Southern California who get their drinking water, people in the Bay Area who get their drinking water, the Delta. Over 20 million people getting their drinking water from the Delta. This is about farming and communities in the Delta area that have not had this important source of clean water for so many years and are very excited at the possibility that we're going to actually finally restore the river. So that's what we're trying to do. I can't give you any predictions about when the battle will end, when the appeals will be over, but that's where we are today. Thank you very much. All right, I can do it.
Don't go away.
Okay.
You're going to have to.
Oh, yeah.
I just wanted to say that there will be a tape of the talk available from the archives, and a week or two, or in 2 or 3 weeks it would be possible to go on the archives website and get the talk. So I know there's a lot of content in it.
Sorry.
Okay. So we have 15 minutes or so for questions. And one, you don't even need to call.
Okay.
You can be able to answer yourself.
Okay. Thanks, sir.
You mentioned at one point there was a belief that it needs to go to farmers were diverting the water for their uses. I was curious, there's a lot of diversions along the river. What kind of rules govern what people can take out or not? Is it a free-for-all, or do they have set limits?
There's the rules and then there's the free-for-all, and they're both accurate descriptions of what goes on. There are provisions of state law, for example, Section 1707 of the Water Code allows you to actually transfer the water from one place, let's say Friant Dam, all the way downstream for environmental purposes, and that allows you to protect the water in stream so that nobody's allowed to divert it. Whether they do divert it is a police enforcement headache that people all over the West are confronting now as they try to restore these streams. During the experimental project we did in the year 2000, nobody diverted. And why? Because we were working with the farmers and they called them all up and said, we're doing this, this is important to us, we know who you are, don't divert the water. I don't know how much there would be diversions if there was a court-ordered release, but what would happen is the way you do this, and there are other streams where Section 5937 has been implemented, for example, and they look at points along the river that need to have a certain amount of flow show up at a certain time or a certain temperature or a certain depth to make sure you get the water you need at the certain place for the fish. And you monitor that. And so if the water doesn't show up, they just need to keep releasing more. So in a sense, it becomes the incentive for the Bureau of Reclamation or its customers to make sure that they do whatever is necessary to discourage people from taking that water that they are trying to release for this environmental purpose. So you can make it work. It's
Those pumps don't have a permit associated. If you go down to San Joaquin,
there's permitted and unpermitted diversions, and that's an issue throughout the state, of course. But and you could do a whole stream adjudication. I mean, San Joaquin River is over appropriated, and there, you could try to sort it all out. In the water business, we all avoid those because they take forever and nobody wants to go there. But you could try to actually figure out what every single person's right is for diversion, and that's part of what the debate will be in the coming years. Will be all right. Let's say you release the first amount of water to Mendota Pool, and the exchangers want the exchange contractors, they want to take that water, but you need the water to keep going for the salmon. How do you blend that? And that those are real issues. I mean, this is complicated. All of those are legitimate issues that need to be addressed. But the law does allow for keeping that water in stream. There's no question about that. Yeah,
how much water do you think it will take to restore the river? Are you talking about 10% of the flow or 50%?
Good question. Question we get asked a lot. And there is no definitive answer yet. That's one of the things that will be very much at issue in the trial. What I can say is that on the three major tributaries north, the Merced, the Tuolumne, and the Stanislaus, the range is between, let's say, 10% and 25% to keep a very healthy agricultural economy and meet the needs of all the existing users, and also keep salmon in the stream and meet downstream water quality. I'm sure if there were environmentalists in the room from each of those streams, they might say, well, we'd like more, or it's working better here, not so well there. But in general, that gives you the range. Now, the San Joaquin has been studied at various times, and when the state looked at it, they thought it might be in the neighborhood of 140,000 acre feet to 200,000 acre feet. When the federal government looked at it, they came up with very similar numbers, maybe a little bit over 200,000 acre feet. When the Friant and NRDC coalition scientists tried to come up with a hypothetical hydrograph so that we could then run the numbers on the water supply side, because we couldn't figure out, well, how do you generate the water you need for the river if you don't have something to start with as a hydrograph for the river? We went high. We aimed high, and we said, okay, let's assume it's a full 350,000 acre feet. How do we do it? And we, again, found 5 different bundles of strategies to meet a hydrograph of 350,000 acre feet. A lot of people don't think it's going to take that kind of water supply, but we don't have the exact answer yet. Sure.
I would like to look at this from the point of view of science and technology. Ideas in science and technology evolve over time. Science makes fallible, makes changes. 1940s and 30s, science and engineering thought that we move lots of water from point A to point B or solve all of those problems. But that is not fair to challenge. Civil engineering is very much understanding it's not more complicated. But still, we make decisions based on science and technology, and then we have nature's limits and the contradictory of climate and so forth. So, based on science, we make economic decisions. We simply cannot act on the conflict, which you already said, but there are still some lawyers who will argue against it. And so it doesn't stand for common sense. If you accept the limitations of science as an evolving thing, that science makes mistakes and it must have a chance to correct itself. And then nature changes, we have a finite system. And so, we think that anybody would argue that he would sign up these contracts in perpetuity. Doesn't make sense. It exists in one of the most educated countries in the world. Well, it happened in any of the third world countries.
Well, you know, I thank you for the question, and I must say it is striking to. I wish you could have been there in 1989, and have the opportunity to hear a prominent official from the Bush administration, the head of the regional office of EPA, say, a lot of things have changed in 40 years. The population of California has changed dramatically. The water quality, the impact on our fish and wildlife, and in fact, the views of the public about the importance of those environmental values. It's all changed. And that's why you had a 40-year contract instead of a 200-year contract, so you would re-examine that. Joe mentioned at the very beginning that there's a case pending in the US Supreme Court, and I thank you for giving me a chance to come back to it. The argument, the issue there, I mean, there are procedural and jurisdictional issues, which I won't get at, but the lawsuit that's involved, this is a crazy case called Orff versus the United States. Mr. Orff is a landowner in the San Joaquin Valley, and the position that he is taking is that the deal I got in my original contract is fixed, and you cannot take any water back for the public. No water for water quality, no water for endangered species. If you do that, it's a breach of the contract, and that contract gives me a property right, so you violated the US Constitution because it's a taking, and you must compensate me. And we have been fighting this. NRDC intervenes in basically every one of these cases we can. We have filed amicus briefs in the claims court in Washington when we can't intervene, because if we go there, if we adopt this idea that whatever some low-level bureau official negotiated, whatever deal they cut in 1940s, ties the hands of all future Congresses, ties the hands of all future courts of any legislation, state or federal, to bring some water back to the public, to protect the public, you know, that's it. I mean, it's crazy. And as you say, it makes no sense scientifically, it makes no sense in terms of technology. Now, the fact is, the contracts don't even say that. You open up the contract, and the first thing it says, if there is a shortage of water for the contractor. In other words, if we can't deliver water to you because of drought, you know, there's no such thing as a fixed quantity of water in California. I mean, some years you have a lot, and some years you don't. Or because of a physical error in operation, let's say, you know, there's something wrong with the canal or whatever, or any other cause. That's what the contract says in the Supreme Court case. It says any other cause. If there is a shortage due to any other cause, no liability to the United States. Now, if any of us had signed that contract, we would think we would have a hard time suing for a breach of that contract when the water didn't show up. But here we are. That case is going on for 12 years, and the case is pending before the US Supreme Court, and I'm glad Joe thinks that we will win. I think if we win, it'll be on very technical jurisdictional grounds about whether those people could even bring the lawsuit. But the underlying issue is critical, and I'm sure you know about this Tulare Lake case where, for the first time ever, this administration decided not to appeal a decision by a court upholding the right of the contract holders against the Endangered Species Act. For the first time ever, they said, we will pay you $16 million in damages for having suffered the harm of complying with the Endangered Species Act because your water contract, you didn't get all the water you were promised. A terrible settlement, completely crazy, and a big victory for the property rights activists. But hopefully that's not the way that the pending Orff case will go. Up in the back there?
When you win, you'll be sending water down a channel that's been dry for 40 years. How far, it seems to me there'll be erosion of presumably pesticide laden. There's a lot of environmental effects of doing this. How far along are people in planning how to do this? It just seems like a fascinating challenge to me.
Yeah, and what's interesting is that even though state and federal agencies have talked about studying those issues for years, there was never the political will to really do it. It's interesting, Congressman Jim Costa of Fresno used to be a state legislator for many years, and when he was chairing the Assembly Water Committee and then the Senate Water Committee, he was a big fan of protecting the river near Fresno, at least the parkway along the riparian corridor, and he actually put together something called the shrimp program, the San Joaquin River Management Program. I see that Tim Ramirez from CalPET has just arrived, and he has been chairing shrimp meetings for a long time. There are studies underway. There are people looking at different pieces of this, how to help the wildlife refuges along the way at the same time, what to do about these water quality issues, what to do about runoff. In about a week or two, the federal government's going to release a 1,000-page environmental impact statement on what to do about the drainage problem. 20-year problem. They've been studying it. And they're going to look at possible land retirement in the west side of the San Joaquin Valley. So I can't say the science is all finished. I can't say that every question has been answered. There's obviously a role for adaptive management as well. But there is enough known now that you can do this. There are ways to deal with the loss of habitat. There are ways to deal with for example, one of the issues you hear a lot as well, that place right where the first part of the river dries out, a lot of that water may seep through and it goes to the groundwater. Yeah, huge benefit for the people who pump that groundwater. All of a sudden, the U.S. government's going to be recharging their groundwater. Well, that's a benefit, a community benefit that needs to be analyzed. It's not an unlimited loss. And in fact, when we did our experimental projects, the losses were much less than people expected. But all of that is being factored into the analysis that the parties are doing. And also, I know the federal and state governments are both now starting to do more studies to get ready, as you say, in anticipation. Sure.
I was thinking in 1908, Oliver Wendell Holmes wrote a case for the Supreme Court where he said, that one whose rights are limited to begin with, cannot extend them by making a contract of them. And it was a pretty good opinion, I think. But that was 1908. In the interest of things like embers and no flows and stuff like that, universities, why hasn't anyone just come up and made a public trust case?
Well, there was actually a public trust petition filed to the State Water Board about the San Joaquin River and Friant Dam. And the State Water Board considered it and decided not to have a hearing on it. And they sent a letter back and they said, there's this group called NRDC that has this lawsuit pending. Yeah. And the issue there is whether the federal government is actually required to follow state public trust laws, such as the Public Trust Doctrine or Section 5937. And we, the Water Board, have been participating as an amicus. And we are going to defer any ruling on your public trust petition until that case is decided. Now, they may not have thought it would still be going on at this point, but I'm sure they were relieved to pass it back to the court rather than decide it. But interestingly, in a few days, the federal government, bless their hearts, will be filing a new petition, a water rights petition, to the State Water Board for a change in the permits at Friant Dam. And their plan is to reopen these permits. I'm sure this is making the water districts a little bit apprehensive. The purpose is they want to do two things. They want to expand, here we've been making this argument for 16 years that you're not releasing any water for the environment, you're taking too much out of the stream. They want to increase the diversions from the river and expand the place of use where you're allowed to use the water to allow two things: a golf course and a gambling casino. and that will be filed apparently in the next few days to the State Water Board. So it may be that public trust issues are going to be front and center once again in front of the State Water Board. I don't know how they'll handle it. So.
Since the mid-70s, the snowpack in the San Joaquin Basin has melted earlier, an average of a week to 2 weeks since the mid-70s. And I'm curious how the regional climate change model projections may or may not be influencing this case and the debate.
No, in 1989, we filed our first motion for summary judgment on our first NEPA claim. And at the time, we submitted a declaration from Dr. Peter Glick, who's a good friend of ours, who at that time said one of the reasons they need to do an EIS is their assumptions about hydrology are all wrong, and then climate change is going to change all that. Here we are 16 years later, and the Bureau's still not doing that. We just filed a lawsuit 2 months ago on what they call the operating plan, OCAP, the whole plan for the joint operations of the two massive projects, the federal and state project. We said, you did this entire analysis under the Endangered Species Act, you found that there's not going to be any jeopardy to any species under either the federal or the state Endangered Species Act, and you never once, and this is a long time, going 40 years into the future, you never once considered the effect of climate change. So the short answer is the federal government's not looking at it. We think it is an issue that needs to be considered. A lot of times, some elected officials immediately say, well, if there's going to be climate change, then we need more dams. We're just going to have more dams. And that's not the right short answer. And in fact, there's a lot of people who think that the answer to all problems on the San Joaquin River is building new dams. Let's spend $1 billion, wait 15 years, we'll have a dam that'll solve everything. It's interesting, this year they're releasing as much as 500,000 acre feet of, quote, surplus water on the San Joaquin River. And it's still not reaching the delta yet. I mean, they're diverting it, they're taking it, they're putting it in all kinds of places. It's not because, gee, we need a dam that would take care of it. There's all kinds of ways that they can divert that water and use that water, and there are a lot of people interested in it. But you're right, the climate change issue is something that it has to be factored in, and we have encouraged the government to do that both at the federal level and the state level. I know you had a question.
Two parts. What was the pre-dam flow of the river? And then secondly, how many farming units are represented by the Freon Association?
On the second question, they claim there are 15,000 farmers. If you look closely, a typical example in the San Joaquin Valley in the Sumner Peck case, they listed 100 farmers. And you look closely, it's the, John Smith Trust number 1, John Smith Trust number 2, Baby John Smith Trust number 3, and then when they finally had a settlement in that case, they said there were 19 families. So the 100 farms became 19 farms, and then it turned out 80% of the money was going to 4 families, and I think that's a little bit what's happening with the Friant unit. So they claim 15,000. People in Fresno tell us it's a much smaller number. This ad today claimed that there were a total of 21,000 farmers in the whole Central Valley project. I don't know if that number is even close, but I think what they do is, for those of you who love the acreage limitation, the old scandal about 160 acres, one of the ways you got around the federal government's limitation on this vastly subsidized water supply was you put the name, each child got a separate 160-acre unit, and you just kept adding. When I first met, I forgot the guy's name now. He's the largest. His family is the largest landowner in Westland's water district right now, and we met, and he said, "You're the guy. You're the reason I have 5 kids." And I was like, "What?" He said, "You're the reason I have 5 kids." Who is this guy? Why? He said, "It's you. You've been trying to enforce the acreage limitation, so I had to have more kids so I could have more land." But that's part of the scam. In terms of the first question, I don't know, Peter, if you have the, Peter Forster is here from the Bay Institute, and he knows a lot of the water numbers, but.
The average annual runoff is 1.7 ounces of and right now, Brian, there is occasional, as Hal just said, in these wetter years, they do get releases. And can I ask a question? Because there's always the low-hanging fruit. And so in a year like this, you have water being released, and you talk about intelligent water management. And those farmers there are a lot of intelligent farmers in Bryant, and they've worked out deals with Southern California urban agencies to store that water, bank it, trade it. Metropolitan is interested in doing those deals. If all the low-hanging fruit and all that intelligent water management is being done right now, what happens when we, after the appeals? How does how does our water, because it is our water, public water, fit into all that water that's now going to be, intelligently managed for Southern California urban areas?
Well, that's a really good point, and something that I think everyone in this room should be aware of, that there's a race going on right now to make whatever deal you're going to make as fast as you can to sort of guard against the future. For example, if you're a rice farmer in the Sacramento Valley, why are diversions going up in the Sacramento Valley? These folks have the most generous contracts imaginable, 8 acre-feet per acre of free water, not bad. And they don't even take, a quarter of it most years. 500,000 acre-feet of water sitting in the federal project, never even taken by the people who've got their contract right to it. And all of a sudden now they're starting to take it. Why? Because they want to show actual use so they can turn around and sell it to Los Angeles. They get it for free. They sell it for $125 an acre-foot. Not a bad deal. They just signed another 40-year contract to keep that deal going. It's happening all over. And one of the things we're seeing in Friant, as Peter mentions, those very state-of-the-art creative strategies, that technology and that science that we helped them develop during the settlement process, are they using it to help us restore the river? No. They're turning around and investing in it to sell the same water, the same storage capacity, the same strategies for profit to urban Southern California. That hurts the river. That's not fair. It's our, as Peter says, it's the public's water. The river has an unmet need that really needs to be addressed before we start expanding diversions so that we can transfer the water to developers in Southern California. I know you've had the question. Yeah, one more. Sure. Go ahead.
I have a two-part question. Has it been possible to get farmers to grow crops that need less water? And also to see if they can change their irrigation practices to use less water, like when and how they water and whether they use drip irrigation, things like that?
Absolutely. Absolutely. There have been some big success stories in the San Joaquin Valley, both on the west side and on the east side. Two quick examples. When one of the Friant contractors needed to achieve a reduction in total water use to meet another goal. One of their goals was to actually do a deal with the Metropolitan Water District, and they needed to they sat around and decided and tried to figure out what's the easiest, fastest way to achieve the water reduction we want. Guess what? They started raising prices. Surprise, surprise. They did some tiered water pricing. They did some encouragement of conservation. They encouraged some of their farmers to switch crops or invest in more state-of-the-art irrigation efficiency equipment. And you know what? It reduced the water use just as they wanted to. On the west side, some of the people with drainage problems, and this has all been written up by the State Department of Water Resources, realized that a big part of their problem was that the excess water, the water that they were using for irrigation but which the crops didn't really need, was coming out as irrigation return flow. It was coming off as runoff, and it was toxic with all those pesticides and selenium and agricultural drainage problems, and that was giving them a water quality problem. So they had to reduce. What did they do? Same things. Tiered pricing, encourage conservation equipment, subsidizing people to use less water instead of more water, and it worked. Again, you bring very significant reductions, and you can do this. Water conservation really works. It's not rocket science. You can if you invest in it, if you do state-of-the-art work, whether on the urban side or on the agricultural side, you really can bring those water use amounts down. And so that's another reason that gives us hope that we can have both a very healthy agricultural economy, a growing urban economy and urban population, and a restored ecosystem in our state. Thank you all for bearing with me. I appreciate it very much.